Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt on the radio, on Facebook Live, on YouTube, and on talklawradio.com. Today's Sunday, and we're going to be talking about a court case that the media has not been talking much about. It's a challenge to the constitutionality of a Texas law in Chapter 129B of the Civil Practice and Remedies Code, which is liability for allowing minors to access pornographic material. This is a PG-13 or PG-18 or whatever they call that, R-rated show. Just if you don't want your kids to know what pornography is, you might want to turn it down. So the pornography website businesses argue that this law that requires them to verify the age of somebody accessing their website violates the First Amendment right to free speech. By the way, if you're listening right now, you probably want to listen on Saturday mornings at 11 o'clock in the morning. I usually have a guest with me to discuss hidden legal issue blind spots. I introduce our guest. We talk about that person's education, background, and experience. And then we talk about the law, how it might impact you without you even knowing it. Then we talk about sinners and saints. The sinner is somebody who's probably allegedly committed some crime or has caused some problems that's in the news. And our saint is someone who has been recognized, awarded, or rewarded for doing something good. Then we talk about legacy. Marquardt Law Firm sponsors the show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. And the purpose of writing a last will or living trust and minimizing the estate inheritance tax is to leave a great legacy. So we talk about the legacy of our guest and what he or she wants to leave, or what they've learned from somebody else's great legacy. Today we're talking about House Bill 1181, which amended the Civil Practice and Remedies Code in 2023, which requires a commercial business that knowingly and intentionally publishes or distributes material on website, including social media platforms, more than 1/3 of which is sexual material harmful to minors, to use reasonable age verification methods to verify that an individual attempting to access the material is 18 years of age or older. The bill requires the entity to display certain notices regarding pornography and mental health on the landing page of the website and on all advertisements for that website, and to display information on the U.S. Substance Abuse and Mental Health Services Administration helpline on the bottom of every page of the website. So the court case I'm going to be talking about is the Free Speech Coalition versus Attorney General of Texas. The Free Speech Coalition filed the complaint, the lawsuit, and a motion for preliminary injunction, which is a method to stop Texas from enforcing the law that it passed. The district court, the United States District Court for the Western District of Texas in the Austin Division, decided to grant the injunction. So for a period of time, the state of Texas was prevented from enforcing the law that it had just passed. The state of Texas appealed that court opinion, and the Fifth Circuit of Appeals, well, first there was a stay, which means that the injunction was stopped. And then the Fifth Circuit vacated the stay, and now the court case I'm going to talk about today goes to the merits of the injunction. So whether there's a stay or not a stay, I know that's a weird term for those of you who aren't lawyers, but that's sort of a temporary decision. And so now this court case is to decide finally whether there's going to be a injunction or not. So the issue is whether this law that requires pornographic websites to verify the age of people visiting those websites is unconstitutional because it prohibits speech. Or is the law unconstitutional because it compels speech by requiring it to have that health warning? So like I was saying before, House Bill 1181 in 2023 regulates certain entities, those pornographic websites. And so I wanted to explain further what this harmful material might be to minors, or at least how is it defined in the law. And so the law defines sexual material harmful to minors to be material that the average person applying contemporary community standards would find, taking the material as a whole and with respect to minors, is designed to appeal or to pander to the prurient interest in a manner patently offensive with respect to minors, exploits, is devoted to, or primarily consists of descriptions of actual, simulated, or animated displays of, or depictions of explicitly described sexual material, and taken as a whole lacks serious literary, artistic, political, or scientific value for minors. So what's interesting about this case is that the law only required the websites to have age verification, but it left that the method of verifying age up to those websites. It just had to be reasonable age verification methods, which could have been outsourced to a third party. The options include the use of government-issued identification, but that websites may alternatively require digital identification or may use other commercial reasonable methods. But the verification may not retain any of the individual's identifying information. So you can imagine, if you know anything about the internet or with privacy and identity, that accomplishing all of those objectives would be somewhat difficult. At least I would imagine so. So the court vacated the injunction against the age verification requirements based on Ginsburg versus New York, a 1968 United States Supreme Court case which discussed sexual material that would be obscene from the perspective of a child. The website businesses said that the law had to be strictly scrutinized, and if it violated free speech in any way, it would have to be overturned. But the court here said that the proper standard of review was rational basis. And so the standard of review is how the court analyzes whether the law violates our constitutional rights. And there's different standards based on different constitutional principles. We don't have time to go into all of that today, but applying the rational basis review, the age verification requirement was found to be rationally related to the government's legitimate interest in preventing minors' access to pornography. Therefore, the age verification requirement does not violate the First Amendment. So the district court made an error in stopping the state of Texas from enforcing the age verification requirement. But the court did affirm the injunction with regard to the health warnings. So when a law requires these website providers to write something on their website, that's called compelled speech. And it says, we affirm the injunction in regard to the health warnings because of a case called National Institute of Family and Life Advocates versus Becerra, and ruled that House Bill 1181 unconstitutionally compelled the plaintiff's speech. When I got started researching this case, it reminded me of all the Supreme Court cases that also analyze whether the government can regulate pornography at all. And so we'll go through some of that. The Attorney General for Texas issued a press release that says, Texas Attorney General Ken Paxton secured a significant win in the U.S. Fifth Circuit Court of Appeals against pornography distributors suing to stop Texas from implementing a new law requiring pornography sites to verify whether a user is 18 years of age or older. So, I have kids. You might have kids or grandkids. You might know other kids. You probably don't want them spending their time looking at pornography on the internet. So the pornography industry, in response, came out with some tweets. So you can imagine that's like how you make a public comment about something. Because of the state's now allowed to enforce its law, state of Texas filed a lawsuit against AYLO Global Entertainment in the district court, Travis County, Texas, to enforce the law. And it was seeking $1,600,000 in damages, plus $10,000 a day for every day that the website provider does not verify age since the lawsuit was filed, and for $10,000 a day after this judgment is signed. But because of this lawsuit, Pornhub, which is one of these websites, said that it wasn't going to operate in the state of Texas, basically. So they put on their website, I didn't go to the website, by the way. I don't do that kind of thing. But I went to Twitter X, and somebody just commented, made a post that said that this is what they saw on the website. So it wasn't me. I didn't do it. But Cameron Abrams, who's a reporter, said this is what was on their landing page. Dear user, as you may know, your elected officials in Texas are requiring us to verify your age before allowing you access to our website. Not only does this impinge on the rights of adults to access protected speech, it fails strict scrutiny by employing the least effective and yet also most restrictive means of accomplishing Texas' stated purpose of allegedly protecting minors. So they're just not going to operate in the state of Texas. Let's see. While safety and compliance are at the forefront of our mission, providing identification every time you want to visit an adult platform is not an effective solution for protecting users online, and in fact will put minors and your privacy at risk. Attempting to mandate age verification without any means to enforce at scale gives platforms the choice to comply or not, leaving thousands of platforms open and accessible. As we've seen in other states, such bills have failed to protect minors by driving users from those few websites which comply to the thousands of websites with far fewer safety measures in place which do not comply. Very few sites are able to compare to the robust trust and safety measures that Pornhub currently has. I don't know what those trust and safety measures are, but they're saying that because they can't comply, these kids are going to go to other websites that don't comply on purpose, and they're probably not going to comply with any law. So I found some information about what they call device-based age verification. This is a method that could be used to verify a user's age. It says, with respect to privacy, contact your representative. Device-based age verification refers to any approach to age verification where the personal information that is used to verify the user's age is either shared in person at an authorized retailer, inputted locally into the user's device, or stored on a network controlled by the device manufacturer or the supplier of the device's operating system. Whether through pre-installed content blocking and filtering software, the disabling of web browsing permissions, or other means, the user will then be prevented from accessing age-restricted content over the internet unless they are age verified. I wish they had done this 18 years ago when my kids were using the internet, because it was like the Wild West. We didn't know how to control what they were doing unless we were just standing over their shoulder. If the manufacturer could create a laptop or an iPad or a phone that had these specific blocking technologies in it based on age, then the kids wouldn't have been able to go around all of the software blocking measures that parents try to use. So the Supreme Court has ruled on cases related to pornography and speech many times. Some of these cases are Roth versus United States way back in 1957, which was a case related to pornography and speech. Miller versus California, 1973, the Supreme Court established a three-part test to determine if something was obscene and could be banned by the government. And you might remember that term, prurient sexual interests, work that is patently offensive by community standards, a publication that lacks serious literary, artistic, political, or scientific value. And in 2002, these aren't all the cases, these are just some of them, but in 2002, there was Ashcroft versus Free Speech Coalition, same entity that had filed the court case asking for the injunction, in which the Child Pornography Prevention Act of 1996 expanded on the Miller versus California decision by banning images of minors appearing to engage in sexual activity, even if they were not real children. Obscenity is not protected speech. This is what the Supreme Court said in 1957 in Roth versus the United States. That's why, even though it is speech, it's not protected speech. The Jacob Ellis versus Ohio case in 1964 is one that established the national community standards when evaluating instead of local community standards. And there was at the center of this case was a motion picture. And the justice in this case, Potter Stewart, is often quoted as having saying, "I know it when I see it, and the motion picture involved in this case is not that, hardcore pornography." So that, looking back on it now, you think, well, how can the justices of the Supreme Court review every single pornographic publication for him to, on a case-by-case basis, decide whether something is pornographic or obscene? That's just not practical. He must have looked at a lot of obscene things to decide that was that he could figure it out by just looking at it. There was Ginsburg versus State of New York in 1968. This was a Supreme Court case that decided that children do have no right to pornography. So these are important issues facing our children these days, and of course we want to keep our constitutional rights, but we want to balance that with laws that protect our children. And that's why we use the rational basis test, because it's an important state interest protecting children from the harmful effects of obscene pornographic material, and the right for other people to produce that type of speech or that type of content. I wanted to let you know about our YouTube channel. If you're listening and you like this show, please show your support by going to YouTube, search for Talk Law Radio, look for the Lady Justice logo in the red, white, and blue colors, and click subscribe. You can watch high-quality 10-minute segment shows on that site, and you can search for different topics, and this could be your way of learning about things that the mainstream media doesn't talk about. Something interesting about this law that requires age verification was that there was an exemption for a news gathering organization, and so I had to look that up. I wanted to find how is news gathering organization defined, and it includes an employee of a newspaper, news publication, or news source, printed or on an online or mobile platform of current news and public interest, who is acting within the course and scope of that employment and can provide documentation of that employment with a newspaper, news publication, or news source, and an employee of a radio broadcast station, television broadcast station, cable television operator, or wire service who is acting within the course and scope of that employment and can provide documentation of that employment. So, if you like this content, tell a friend. Tell them about Talk Law Radio and about how we help you discover legal issue blind spots by listening to Todd Marquardt, that's me, on the radio. And I came up with this idea because I was reflecting one day and I thought, we have a lot of laws out there, and people probably don't know that there's laws that impact them without them knowing it. And I thought, well, God started with one law. He said, don't eat from the fruit of that tree. Then he gave Moses the 10 Commandments. And now we have municipal, state, and federal lawmakers that won't stop creating new laws that impact all of us. And sometimes you can accidentally break the law without knowing it and get into trouble without meaning to. Or you might be missing some legal opportunity that the law provides that you don't know about that could really benefit you or your family or your business. If you want more information about the law, go to marquardtlawfirm.com. You can read articles that have been published over the years about estate law, business law, elder law, probate and guardianship law. Well, that's all the time I have for today. I'm Todd Marquardt, Talk Law Radio. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.